Hi everyone, Chris Stanton here again from the law firm of Klemp and Stanton in Mendota Heights, Minnesota. This is the third of my educational videos for my clients and other interested people in estate planning. Today we're going to talk about documents that sometimes are overlooked. I mean, generally people think of estate planning, they think of a will or they think of a trust and nothing else. Well, today we're going to talk about supplemental documents that I always include when I'm doing work for my clients, whether it be for a will or for a revocable trust. So we're going to talk about today what's called financial durable powers of attorney, durable powers of attorney for healthcare, and healthcare declarations. These are definitely documents that need to be included in your estate plan. But first today you got to find out and understand what they're for. The financial durable power of attorney is where you give to someone the ability to act on your behalf with regard to financial matters. Generally it comes into play when one becomes incapacitated, but it doesn't necessarily only begin when you become incapacitated. Most often, particularly when you're talking about durable powers of attorney, they go into effect immediately when you sign them. So a financial durable power of attorney is a document that a person signs that gives someone the power to act on their behalf with regard to financial matters, typically, for purposes of paying bills and so on. Things to know about the financial durable power of attorney. Financial powers of attorney can be drafted so that it goes into effect as soon as you sign it. When you create and sign a power of attorney, you give another person the legal authority to act on your behalf. This person is called an attorney in fact. People usually give these attorneys in fact what's called broad powers to handle all financial matters, but you can limit it if you wish. Also, fourth, the attorney in fact is required to act in your best interest to maintain accurate records and to keep your property separate from his or hers, and also to avoid conflicts of interest. So in a nutshell, you give someone the ability to act on your behalf with regard to financial matters. And this is a separate document. Many times people will get confused and think that it's written into the will or whether it's written into a trust. No, it is a completely separate document that you would sign that goes along with the will. It's not in the will. Your financial power of attorney ends when you revoke it. You can change it at any time. If you lose faith in whoever you put in as the power of attorney, you just simply revoke it. The way you do that is you notify the different financial institutions that you work with that the power of attorney that you had given to someone is hereby revoked as of right now. Another way that the power of attorney ends is if you pass away. Oftentimes someone will pass away and then I'll have their eldest son or what have you say, well, I have power of attorney so I can access the accounts. Well, no, powers of attorney end at death, and you need to be aware of that. That's when at death the will would take over or the trust would take over, so to speak. Third, a court could invalidate the document. It's rare, but it could declare the document invalid. Or the power of attorney ends when there isn't any attorney in facts available. Nobody that you had named can do it, whether they had predeceased you or just were unable because they didn't want to act. Some of the things you need to know about these financial powers of attorney include they can use your assets to pay for everyday expenses, and that's typically what it's used for. They can buy, sell, maintain, pay taxes on. They can collect Social Security, Medicare. They can invest your money. They can handle transactions with banks and other institutions. They can buy and sell insurance policies and annuities for you. They can file taxes, operate your business, claim property you inherit. They can transfer property to your trust that you've already created. They can hire someone to represent you, such as me, and also manage your retirement accounts. So when you do financial durable powers of attorney, whoever you put in charge will be able to do many, many different things related to your financial affairs. Now, there's also what's important, and again, this is separate from the financial durable power of attorney. People also need to think about their healthcare directives. And there's different types of healthcare directives. All of these are for purposes of putting someone in charge to make medical decisions for you. Well, what is a healthcare directive? Well, a healthcare directive is a document that informs others about your wishes regarding your healthcare. It allows a person to act on your behalf with regard to your health matters. It also allows you to name an agent if you want someone else to decide for you, and you must be 18 years old to make one of these healthcare directives. But it's very important, as I've stressed at the beginning, not only do you need a will, financial powers of attorney, you also need healthcare directives. In order for a healthcare directive to be legal, so to speak, there's certain requirements. It has to be in writing and dated. You have to state your name. It needs to be signed by you, or authorize someone to sign on your behalf who can understand and communicate your healthcare wishes. You have to have your signature notarized or have 2 witnesses. You need to include the appointment of the person that's going to make the decisions for you in the document. So, it's pretty standard what you would think, but you need to make sure that you follow all of these requirements in order for it to be effective. Now, there's a couple of different types of healthcare directives. I do one that's called the Durable Power of Attorney for Healthcare, and I also do for my clients what's called the Healthcare Declaration. The Power of Attorney for Healthcare is where you give someone the ability to act on your behalf in the event that you became incapacitated, but you aren't necessarily on your deathbed. Let's say you had Alzheimer's disease, or for whatever reason you were unable to act on your own behalf, but you weren't going to pass away anytime in the near future. Well, then you want to have somebody be able to make medical decisions as to where you're going to stay and what type of care you're going to receive and so on. There's also what's called the Healthcare Declaration. The Healthcare Declaration is the pull the plug will, if you wish to view it that way. That's where you don't have a reasonable expectation of recovery and you want someone to make medical decisions for you with regard to end-of-life decisions. So if we review, durable power of attorney for healthcare is where you name someone to act on your behalf with regard to financial matters when you're not necessarily on your deathbed, but you're incapacitated. Durable power of attorney is one type of healthcare directive. It's set there out so your wishes for your healthcare can be taken care of in the event you're ill or can't speak for yourself. Powers of attorney for healthcare. When you have a power of attorney for healthcare, you name a trusted person to oversee your medical care and make decisions for you if you're unable to do so. They're also referred to as an attorney in fact or healthcare proxy. They'll work with the doctors and other healthcare providers to make decisions with regard to where you're going to stay and what type of care you're going to receive and so on. Then there's the Healthcare Declaration, as I mentioned before. This is the pull the plug. This is where you don't have a hope of recovery. Now again, it doesn't come into play when you have a cold or a headache. It's just when you don't have a hope of recovery. So generally, a healthcare declaration describes certain life prolonging treatments. You, the declarant, indicate which treatments you want to receive and things that you don't want to receive in the event you're in a situation where you've reached terminal illness or you're in a permanent vegetative state. It doesn't become effective until you're incapacitated. Until then, you're able to say what type of care you want to receive and so on. Doesn't mean you give up any of your rights when you sign these. As long as you're able to communicate, you're in control. This is what a little short run on supplemental documents that go along with the will and the trust. Today we talked about financial durable powers of attorney. That's where you give someone the ability to act on your behalf with regard to financial matters. And we also talked about healthcare documents, specifically durable power of attorney for healthcare, as well as the Healthcare Declaration. Make sure you include those in your estate plan. You don't have to have a substantial estate to need these. You always want to make sure at a bare minimum you have a will, you have a financial power of attorney, and you also have a healthcare document. Again, my name's Chris Stanton. I'm with the law firm of Klemp and Stanton in Mendota Heights. Certainly give me a call or email me if you wish, if you have questions, and then we'll go from there. Have a nice day, and we'll see you next time.